Welcome again to the Melling Law YouTube channel, where we talk about different estate planning topics. Today, it's YouTube Tuesday, and we're going to talk a little bit about cabins. As you can see, I'm a little redder than usual. I just spent the long weekend up at the family cabin. And these, and when I refer to cabins within estate planning, really that's any kind of secondary property, whether that's a cabin, empty piece of mountain property, or a vacation home like that you might have in more like a resort type community. Whatever your family cabin is, or whatever that vacation home is, or secondary vacation area, keep in mind that within the context of estate planning, they present a unique, I guess, hot spot for dispute, and we want to account for that in the estate plan. Maybe it's because it's more sentimental than other pieces of real estate or a family business in a lot of cases. Maybe it's because the value may be higher than some of the other estate assets, but we do want to account for it. So we're going to run through two of our main strategies for encountering this in your estate plan. So keep these in mind. If your estate plan accounts for these, great. And if it does not, you might want to revisit your estate plan and make sure that your secondary property or vacation home is taken care of and planned for appropriately. Now, the first one is the simplest. It doesn't necessarily work in all families, but it can be the simplest way to address a secondary property within an estate plan. And that is that we just order it sold, and so within the trust or the will, we just state that this property is to be sold and the proceeds split equally, but we do leave in an option to buy. So, and we'll usually go in age order or any other order that's going to be going to make sense. But that way, any of the siblings can, in a specified order, opt to purchase that secondary home from the estate. And you might want to use an independent appraiser. There are a few other things you want to address there. But the general idea is they have the ability to purchase that estate. They may be able to use part of their share of the inheritance. But that way the other siblings are paid off, but the cabin gets to stay in the family. The other way that we'll be able to do that is we'll create some kind of cost sharing arrangement. So usually we'll have this cabin put into an LLC, or maybe even keep it in the trust, but have an accounting mechanism similar to an LLC, where we have a set beginning value or pro rata share, but we're going to credit anybody who's paying toward improvements on the property, because that's where a lot of the disputes come in. Everybody wants to share the property, have some kind of timeshare arrangement, whatever that may be, but nobody wants to actually pay for improvements. So you set up some kind of governing structure, number one, to decide what types of improvements are countable or creditable to those who are paying for the improvements, and two, some kind of system to account for what is being paid in. That way, if it is ever sold in the future, or if someone passes away and it passes to their children, or that share passes to their children, we just want to make sure that whoever's been paying for those improvements is credited that amount, and maybe we have some kind of formula for inflation or added value to the property, and that's where it gets a little more detailed, and it's really on a case-by-case basis. But those are your two main estate planning options for these secondary properties. Either it's going to be sold, but someone has the option to buy it using their share and buy out the other siblings, or we develop some kind of cost sharing arrangement, and the primary purpose of that being that this property doesn't fall into disrepair, but those who are paying for the repairs can still be credited for those repairs. Thanks for watching. If you have any other questions, you can always reach out to us at 435-572-0807 or at mellinglaw.com.